Welcome everybody back to our first session of today, which has the nice title, Zeus has thrown his lightning bolt. And if you see it together with the main title of our conference, Gods in Transit, this is not just a misspelled version of goods in transit. There is some other meaning behind it. And as we are in Athens, I thought we could as well make a little comparison with the gods, which were already described by Homer as a reflection of his day's society. And it is still true. You just have to think of the gods as the member states and Zeus as the EU. And then you get the picture. The EU has thrown its trademark directive. Well, that sounds quite dramatic. Let me assure you that is sort of dramatic. Lightning has the power to destroy old structures, but it also bears a huge energy. And if we managed to transform that energy into something long-lasting, into something positive, that would really save us a lot of problems. And this is the story we would like to tell you today here, the story of the Olympic gods and the implementation of the trademark directive, because this is what we are dealing in this session, the status quo of the implementation. And if we go back to the Olympic gods, you know, at the beginning there were 12 of them, resembles some other union we have, and also they formed a strong, powerful union. They met on the Olymp. Nowadays it's Brussels, but that's another story. They discussed their problems, they came together to find common solutions for the worldly problems, and they were all different, of course, but they usually try to agree on common actions, common communications, and other common things. And then there was also Zeus. We have a picture even on the cover page of our program, right? So he was the father of the other gods. He was more powerful than all of them together. But he was also caring a lot. He watched, he listened, he tried to settle disputes, and he had some powerful weapons. You know, it started with thunder and lightning, but soon he came up with something like fines and membership infringement proceedings, things like that. So now, one day, Zeus called together the other gods and told them, look, some years ago, we set up this beautiful temple, the Pan-European Community Trademark Temple down there in Alicante. And we used the best architects to build it. We used the most advanced tools. We set up a complete new regulation for this temple. We improved the service, and it's become very popular for the people. They travel all the way down to Alicante to file their requests, and they get a lot of offerings and use the money to make it even more functional and even more beautiful. You have seen that this morning, how much they improve the service down there in Alicante. So Zeus said, now it's time that you also look at your own temples, because they have actually not been renovated for 30 years. And there are some, so many differences in the architectural style. You use different rules and procedures for everything. Look, for example, at the way you handle your revocation and cancellation proceedings. You all use completely different approaches. Imagine, for example, there's somebody who comes to your priests and priestesses in the temple and says, you have granted somebody protection for something which should never have been granted. He acted in bad faith, and also I have the better right. And then you tell him, well, there's nothing we can do. The priests and priestesses don't have any competence to deal with that. You have to ask the oracle. And this poor guy says, my God, the oracle, it's far too expensive and far too long-lasting. I have other things to do. I have to go back to harvest my wine or whatever. So you have taken that decision, the priests and priestesses. Why can't they just take back their own decisions? I don't understand that. And it's sort of true, Zeus said to the other gods. You have to simplify your ways of procedure, make it expeditious, make it efficient. And he gave them another example. He said, look, all the fuss about graphic representation, is it really necessary that if somebody comes to you and seeks protection for wine, you ask him to draw an amphora from 10 different angles? No wonder that your temples are full of paint and statues and models. It's all the 3D trademarks and all the fanciful color marks. But you know, this is not really durable. That will all be vanished in 3,000 years. So, Zeus sat down and he wrote new rules. He wrote a new trademark directive. And he thought of common structure, common basement, common pillars. These things were mandatory. There were also some optional things. The gods were free to decide on decoration, things like that. And he gave the gods 3 years to implement all that. Well, with regard to the proceedings, he was a bit more generous. He said 7 years, because that's a bit more complicated. So, and there we are. There we have the gods in transit. They are in transition from one trademark law to the new one. And as it is the case with gods, they don't do the work themselves. They call upon their heroes, you know, very bright people capable of doing nearly impossible things. And they are the ones, half gods of IP, who try to sort that out and to build these new temples. And today, of course, it's very, very difficult to get the gods on the stage, but we are very lucky to have their heroes here. And I hope that they will be able to draw a picture of the shape of these new trademark temples and also to give us an overview of their discussions with Zeus. Our first hero today is Dr. András Jokoti. He is Director General Legal Affairs at the Hungarian Intellectual Property Office. I do not know, András, whether you have already met Zeus in person? No.
Of course, several times.
Yes, several times. There you go. I think you have traveled many times there and met his representatives. And András, I'm sure you can tell us something more about the discussions there on the Olymp and how Hungary manages to comply with all the demands of Zeus. András, please.
Thank you. Good morning, everyone. So to extend the metaphor a little further, I wouldn't call myself a god or a hero. I'm here representing one member state, one god, but I'm coming from a national IP office. And if we think about the IP systems in the different member states as temples, then I would say that the IP offices are the caryatids of those temples. Now, if we think about the origin of the word caryatid and how these figures were represented in mythology, they were happy maidens dancing around in Artemis's feasts with baskets on their heads, and they had a jolly good time. Now, without trying to victimize ourselves, I mean, IP offices, I mean, thank you very much. I mean, from dancing maidens, we become someone who actually has to carry an entire building on their heads. But we do enjoy this task, and we do think of ourselves as an important building figure of an IP system in a given country. Now that also comes into play when it is about the transposition of the trademark directive, because I think in most of the countries the IP offices do have a seminal role in actually drafting the new rules, or at least they contribute greatly to this endeavor. Now I'm sure that you have heard a lot about this, so I don't want to dwell for a long time on it, but one has to see everything in context. So the trademark reform in Europe consists of different elements. One of them is the overhaul of the community trademark system that became the European Union trademark system. This was about the amendment of the community trademark regulation, then it was codified into the European Union trademark regulation. Now, there came two acts acts with that, adopted by the Commission, also with, in consultation with the member states, obviously. The implementing regulation and the delegated regulation, they both have different detailed rules relating to the procedures at the EU IPO relating to European Union trademarks. So directly, these regulations do not have a direct effect on national laws, but we will see that they do indeed have a very serious impact on the national laws of the member states. Obviously, the overhaul of the European Union trademark system also came with the comprehensive overhaul or review of the EU IPO guidelines as well. Now, together with the new EU trademark regulation came the recast trademark directive, and now that imposes a lot of obligations on member states because all the member states have to review their trademark system and they have to see what they have to change in order to comply with that. And as we all know, many of these changes came in parallel, so many changes that were injected to the European Union trademark system were also injected into the directive, and thus it will be injected into national trademark laws as well. This presentation is not about that, but the trademark reform itself in the EU trademark regulation also renewed the entire cooperation framework between the EU IPO and the member states and their offices, and this results in a lot of cooperation activities, including some very important convergence programs that we will also hear about briefly, because one of them relates to something that we have to tackle these days. Now, I'm in a special position now because I'm not Thomas Eichenberg, I'm Andreas Jokuti, so I'm talking instead of Zeus maybe. I don't know if we can call Thomas Zeus, but I mean, he would probably be happy to hear that. So originally in the program and even in the final program, Thomas is there and there would have been a commission appraisal of things. Now, I think that even though Zeus cannot be substituted, when we talk about the status in member states or how we transpose the directive, maybe at this point, a member state representative is a better place to talk about this, because the Commission will have a very interesting role once they have to monitor the implementation process after the new rules have been adopted, whether they have been adopted in the deadline, whether they are in compliance with the directive. And they also had very important tasks when they had to adopt all the detailed rules necessary to complement the EU trademark directive. At this phase, however, the Commission has to step back a little bit and has to let the member states do their own homeworks. Now, stepping away a little bit from this Olympic metaphor and bringing in something else, member states might feel a little bit like adolescent kids right now, having a dad and a mom. Dad is the Commission and mom is the EU IPO. They are all very caring and supporting, and they are offering everything to help the children, doing their homework. And do you need anything? Are you hungry? Are you thirsty? We are really here to help you. So we have gotten a lot of support, and I'm not complaining, because when the adolescent kids are complaining about their parents' support, it's in fact some form of gratitude. But we sometimes say, okay, Dad, Mom, just leave us alone a little bit. I have to do my homework. We are busy. I don't need a glass of water. I don't need, any assistance. Just, let us be. Because that's what's happening right now, that all the member states are very busy drafting their actual amendments that are needed to implement the trademark directive. But we do have to appreciate moms and dads' efforts, and we all have to acknowledge what has been done so far by these institutions. So the Commission, apart from adopting the detailed rules relating to the EU trademarks, also had a workshop in February where we could discuss all the questions that were raised by member states, actually, and the Commission gave their own interpretation or their own answers to these questions, and that was quite an enlightening session, and that helped an awful lot to all the member states to actually transpose the rules of the new trademark directive. But we also have to see that even though the provisions of the implementing regulation are applicable to EU trademarks, they do have, and that's the arrow over there, they do have a very significant effect on the transposition of the directive, and specifically because of the abolition of the graphical representation requirement about the typology and the representation of the so-called new types of trademarks. Well, I know that you have heard a lot about this, and I don't want to dwell on this very long, because I know that other presentations will also tackle this issue, but it might be interesting to highlight that we are not really talking about new types of trademarks, or not necessarily. It's more about a new typology, and it's more about new ways to represent even old type of trademarks. So when it comes to a sound mark, there's nothing new in that, but there are very important new features regarding the representation of sound marks. Obviously, with the abolition of the graphical representation requirement, there come a few new types of trademarks as well. But when it comes to the architecture of the system, it is not about embracing necessarily much or many new types of trademarks. It's more about an overhaul of the representation requirements. And here, even though I couldn't go into details relating to the different national drafts on this topic, it is very important to see that by way of a common communication drafted by EU IPO and the member states, it is, and it's available to everyone, it's available online. Now the relevant provisions of the implementing regulation serve as some kind of a model law for member states, and the member states undertook, even though that's not a legally binding document, but they undertook that they will align their drafts, their trademark laws to the one enshrined in the implementing regulation. So when it comes to typology and when it comes to the representation requirements, they will do it similarly to the UIPO or to the rules enshrined in the implementing regulation. It also has, the common communication also has some very important passages on acceptable file formats. Even though the member states could not say that they will accept exactly the same file formats necessarily as the EU IPO, but the monoformat approach advocated by EU IPO was adopted by most member states, at least on the common communication level. And the monoformat approach doesn't mean that you can only file trademark applications in one particular file format. It means that when it comes to one certain type of representation, then it should come in the designated file format. So when it comes to a picture or when it comes to a sound file, it shouldn't come in all kinds of file formats like WAV, MP3, and all the other. But it should rather focus on being an MP3, for example. Now, we also had a lot of support from MAM as well. EU IPO organized working group meetings for all the member states. We created a network of reference persons from all the member states. So it was more like an email list, but it functioned really well because we did receive a lot of questions from each other, and all the other offices were replying, and there came out very fruitful discussions from this email list. It's a very simplistic tool. It's not even a tool. It's just sending emails to each other. But because we knew each other, and because we could sit there at the meetings organized by the UIPO, we had the chance to actually discuss these matters between us. And even though there are a lot of differences, even though there are maybe divergent interpretations, but there are very important insights to learn from these discussions. The UIPO also provided reference texts in the beginning to orientate a little bit the implementation process, and in the framework of a so-called pre-legislative convergence, we came up with this common communication that I was just talking about. Now, relating to new types of trademarks, or new types of representation of trademarks to be exact, there will also be a post-legislative convergence project launched. It has just been endorsed by the management board in Alicante last week. This convergence project will deal with issues such as assessing the similarity of these marks or assessing the distinctiveness of these marks. And there will be two work streams, one about formalities and absolute grants and one about about relative grounds, and member state representatives will also be there, and hopefully in the end convergence documents will be produced, which will prevent that the different member states go into very different directions when it comes to these new types of trademarks. Now, about the status in member states. Obviously, I will not give you an overview of 28 member states, but I can say that based on the communications that we are having with others, there is good progress everywhere. I think with the exception of 1 or 2 member states, there are finalized drafts. And by the way, I mean, we should see that implementation or transposition comes at very different levels. So the trademark acts of the different member states need to be amended. That goes without saying. Also, when it comes to formalities, for example, because of new types of trademarks, or when it comes to fees, because maybe one member state or wants to switch to the one class per fee system, then the decrees or regulations, depending on the legal system of the member state, need to be amended as well. So there is a layer of secondary legislation that needs to be amended as well when it comes to the transposition of the directive. Now, the guidelines of the national offices should also be reviewed and overhauled in light of the new requirements or new provisions. And there has to be a very intensive communication campaign accompanying these measures, because just putting out new legislation there will not really help the stakeholders or the clients of the offices to understand these rules. So these are the different things that all the member states have to deal with. And obviously, once somebody starts to touch trademark law somewhere, then come other ideas. Oh yeah, by the way, it has been long overdue to do something about this. It has been long overdue to do something about that. So maybe other trademark-related amendments can also come into play. Generally, one can say that in most countries there are drafts ready. In most countries, these drafts are very close to government approval, and in some countries it is even before parliament. But I can say, by fall, almost all member states will be in the status of a parliamentary debate. Regarding Hungary, we are now in the consultation phase. The office has submitted a draft to the Ministry of Justice. The Ministry of Justice is analyzing the text, but we have already sent out a preliminary expert draft with 1 million disclaimers around it, that this is not the government's position, but this is, the first draft of the package, so that our stakeholders, our professional representatives, and our associations have a chance to comment at a very early stage. And this is the point where I would also like to encourage ECTA to reach out if they want to see the text, because this is not published on a website yet, because it is not endorsed by ministries yet. But this is a good point, or this is a good point in time when these discussions can take place, and then we can take on board any comments that could come from ECTA. Well, there is a shortcoming of a diverse union. We have a lot of languages, a lot of national languages, so these drafts are mainly available in national languages of the different member states. This is the case in Hungary as well, so ECTA will have to find a Hungarian member to review these documents, or another member who speaks Hungarian. You can never exclude that possibility. Now, about the key areas of transposition, I know that I don't have a lot of time left, but this is actually the flesh and bone of the things that we are talking about. As we know, the directive does contain a lot of mandatory provisions and a couple of optional provisions. Now, the ratio between mandatory and optional has shifted a little bit, so there are less optional provisions. Some things that had been optional became mandatory. And It's also a new feature of the trademark directive that now it has procedural rules as well. So not only substantive rules, but also procedural rules, which introduces in a mandatory manner the introduction of administrative proceedings for oppositions, revocations, and invalidations. Now, in Hungary, this is not a big deal, even though the implementation deadline is longer than the general deadline, which is this is January of 2019. But now, for the introduction of administrative proceedings, it's 2023. But Hungary already has administrative proceedings in place, so we just had to review the rules relating to these administrative proceedings, whether they are in compliance with the directive or not. But there is not much to do in that particular country about that. In other countries, this is the biggest challenge of the entire package, because they have to introduce brand new proceedings, and they have to take care of the modalities of all that. Now, in Hungary, there is a special system. It's a bifurcated system. So when it comes to invalidation or revocation, then the applicant of that, the requester, has to go to the office first. They cannot raise those issues at court directly. But the administrative proceedings are available, and the directive does not require more than that. I have talked in a lengthy manner about the abolition of the graphical representation, so I will not talk more about that. Now, there was a complete overhaul in the directive of the system of the grounds for refusal. Now, one could talk until the evening about this, so just highlighting a couple of things, like there is this trio of grounds for refusals for the nature of goods, the functionality or the aesthetical functionality. There now not only shapes, but also shapes and other characteristics come into play, which was introduced because of the abolition of the graphical representation requirement. But I think, and that's a position, that it has a wider effect, and then it means that that any feature of a given sign might render these grounds for refusal applicable. But this is a very interesting time to talk about this, because the Court of Justice of the European Union just handed down its judgment in the Louboutin case, where under the old directive they said that a color is not a shape, so there you go by. Now, under the new directive, this discussion would probably be a little bit more nuanced, and then the real debate whether it has this kind of aesthetical functionality, to borrow something from US trademark law, is applicable or not, or is there or not. At this point, this seems to be settled, but only under the old directive. There is reinforced protection for geographical indications, for traditional specialties guaranteed, and plant varieties. These things have been there already. There has been some fine-tuning and references to other EU instruments, and also bilateral trade agreements which might contain provisions providing for the protection of GIs, for example. So the system became much clearer, and trademark law, EU trademark law, and consequently national trademark laws now have all these rules relating to quality policy, to put it like that, in one place. And even though they have references to other instruments, at least it's clear now what has to be applied. And it's not only an absolute ground for refusal, but also a relative ground now. For bad faith registrations, now it's mandatory to have that as an invalidation ground, but it is still optional to have it as a ground for refusal of an application. Relating to infringements, now come detailed rules about trade names, company names. I mean, using a sign as a trade name or company name, and that can be infringing vis-a-vis a trademark. There is a reference to comparative advertising now. Goods in transit, I'm sure there will be lots of presentations about that, so I wouldn't linger there. The preparatory acts, which are linked to that a little bit, and overruns, which is a very interesting and useful addition. I'm sure most case laws already treated overruns or any type of extension over the bounds of the license an infringement, but this is this particular set of provisions in the directive and consequently in national laws will provide much clearer picture when it comes to the extension beyond the limits of a license given, that it can be considered an infringement. Now we did get a very interesting question, just to give you a little bit of an anecdote here, from stakeholders at home, whether failure to pay the licensing fees could come into this circle. Now, I think that this is not exactly the same as a type of overrun, be it the duration or the territory or anything like that, because that's more like a contract law issue. Once the contract expires because of the failure to pay license fees, then obviously from then on infringement can be established. But as long as it's a contract law dispute, the license is still there. So I would be hesitant to add that expressly into the text of trademark law. Also, the rights of licensees, by the way, I mean, when it comes to litigation, has also been cleared, and it's important. At least there will be an important change in Hungarian law that currently, in order to have rights to litigate, a licensee needs to be registered in the register maintained by the office. But because of the transposition of the directive, this requirement will be eliminated. So now the directive's rules will be applicable. So it's either with the consent of the trademark owner, or if it's an exclusive licensee and they notify the trademark owner and they didn't react, then they can initiate proceedings, but there is no requirement to be entered into the register to have that right. Yeah, we are already at Roman 2. So yeah, the directive covers as well limitations on trademark rights. This is a funny thing, the names of natural persons. So there was a provision that could be interpreted one way or another, and then the Court of Justice of the EU in a case said that no, wait, I mean, this should not be limited to natural persons. So we amended our trademark law a couple of years ago, and now the directive narrows it down again. So as a defense, only a natural person can bring up his or her own name, not companies anymore. So we have to narrow it down again, which poses some challenges when it comes to the transitional regime, which will be the most important part of my presentation. So I think, because I have very little time left, to skip a couple of things. I will not talk about collective and certification marks. We will have some remarks on that from other speakers. Renewal procedure, that's interesting because currently we have different time frames and we do not envisage an additional fee for renewals after the expiry date, but the directive imposes that on member states, so we have to introduce that. So so that will be a significant change. Trademark owners should not wait until the expiry of their trademarks, but they have to act before that if they want to avoid an additional fee for renewal, apart from the regular renewal fee. I think I stepped. Yeah, transitional regime. So I think this is the most interesting part of transposition. When you have to determine, okay, these are the new rules, fine. But to which cases exactly should they apply? So this is the trickiest part, and this was actually the longest thought process to come up with. Something that is not provided for in the directive. So the directive doesn't say anything about this, so it's probably up to the member states, obviously in light of general legal principles in the EU and legal certainty and protection of legitimate expectations, and the case law of the CJU. So I'm not saying that we are in vacuum here, but when you have to draft something that, okay, so to which cases will these new rules apply, then you really have to balance very different interests. There are specific areas in trademark law where this is really significant or really interesting to see. One is, for example, the new and the disappearing grounds for refusal. So when you review the entire system of grounds for refusal, then there will be some things that are new elements, and there will be some things that are disappearing. And in this case, there are lots of things. There are lots of things to take into account. You obviously cannot assess a trademark based on rules that entered into force after the trademark was filed. But you also have to avoid the perpetuation of these marks. So if the mark is not compliant anymore with current trademark rules, and they can be renewed and renewed and renewed until eternity, then the question becomes very pertinent: whether for how long do you want these trademarks to be around, even though they might not even be compliant with trademark rules for 20 years, or 30 or 40. So one probably has to take care of that a little bit. When it comes to the use of marks or infringing signs, also when new infringement scenarios come into play, then you have to be very clear in the rules to which cases, and when it comes to continued use, from which point on the new rules are applicable. And as I mentioned earlier, when there is an additional fee coming in for the renewal procedures, then you also have to be very careful not to put people in disadvantage who had the legitimate expectation of renewing their trademarks without an additional fee. So you need to have a transitional regime. You need to have very detailed rules when it comes to these. Now, regarding the grounds for refusal, the EU IPO's approach is different from what the Hungarian draft is proposing. So the EU IPO said that a lot of the grounds for refusal that seem to be new in the directive have already been there, just elsewhere. So there is no substantive or substantial change. So there is no problem. But when it comes to new grounds for refusal, and this is a very narrow domain, one can say that it only applies to some national parentality rights and the other characteristic proviso of the trio that I was mentioning. But still, there will be something coming into play that is new, and there the EIPO says that these rules will only be applicable for trademarks applied for after the entry into force of the new rules. It's interesting because that doesn't take care of the perpetuation issue, and the Hungarian legislator is considering introducing something similar to the model applied upon accession to the EU, where a lot of new trademarks rules came in, where these marks that are not compliant anymore to the new rules or with the new rules, they are only enjoying this kind of shielding effect until the first renewal. And after the first renewal, they can be attacked. But if that attack is successful, then the protection will only cease from this date of first renewal after the entry into force. I know I'm done. So this means that there will be kind of a phasing out of those trademarks envisaged, which are not compliant with the new rules. At least that is proposed, but we are open to comments. And just as a closing remark, this in the Louboutin case, this is something. It's a prime example, and I didn't even expect it to come at such a good time. When it comes to that. Then maybe there will be a different interpretation when it comes to the same mark as an EU trademark, and maybe a different interpretation when it comes to a national, for example, a Hungarian mark, because the Louboutin mark was shielded from this kind of attack because it's not a shape, but only under the old rules. So the EIPO will probably, if it's an EU trademark, can leave that protection intact forever. But if it's the same about the Hungarian mark, for example, a corresponding mark of Louboutin, then we might say that after the first renewal, then the new rules become applicable. So maybe from then on, they will be susceptible for invalidation. So if you think about it, these transitional provisions can have a very deep impact in certain cases, and that is why one needs to be really cautious when we tread these grounds. I mentioned already a couple of questions raised by other member state experts. These are just examples what types of questions were incoming in our mailboxes in this network of reference persons. We don't have to dwell on these specifically. If you have questions about any of them or anything else, then at the end of the session I will be available, or even in the coffee breaks, the receptions and whatnot. Thank you very much for your attention.
Thank you so much, Andras, for these valuable insights. I would like to reserve questions to all of our speakers for the end of this session, because we are a bit short of time anyway. We will proceed with the next part of our session, which is more even about harmonization. We have seen that all these goals are of course different, and they will deal with these issues of course also in a different way. And who could better describe all these different approaches than Mara Mondolfo. She is an Italian lawyer working for Società Italiana Brevetti. She is also chairing the ACTA Harmonization Committee. The name of this committee already suggests that it deals with matter of harmonization where things still need more common alignment. And Mara, I would like to invite you to come to the stage to start your presentation, please.
Thank you, Caroline. So, on behalf of the Harmonization Committee, I am happy to take you on a brief journey, as brief as possible, through the implementation process of the new Trademark Directive. So we are not facing the wrath of Zeus, who actually is quite a benevolent father, in the words of Caroline. But we should be reminded that this is not a new journey. It actually started 3 decades ago with the first Trademark Directive. So it faced challenges, there were uncertainties to be resolved. Right now, we can say that we are closer to the shore than ever. So our questions are those existential questions of Odysseus. Are we there yet? And does this journey ever end at all? So these are, okay, just to remind you, these are the relevant dates. And as you see, we are only 7 months away from the big date. At the present, Croatia is the only country that, well before the deadline, actually transposed the directive already. Our newest EU member wins the laurel crown. We have a number of countries for which we could access a draft bill, publicly available draft bill, and this is the first and only list I will read to you, so you don't need to worry. It's Austria, Benelux, Czech Republic, Finland, Germany, Hungary, Lithuania, Poland, Portugal, Romania, Spain, Sweden, and the UK. And in Austria and the Benelux, there were also amendments recently that made steps towards the directive, even though it still needs to be implemented. Now, when it comes to identifying the most significant changes that will follow the implementation of the directive, this is less obvious and less straightforward than it could have been for the EU2R, because of course some changes that are very significant in one country, well, some provisions that imply significant changes in one country, in fact, amount to no changes at all in other countries where the provision is already in place and already perfectly complying with the directive. So, how to find our way out this Minotaur's labyrinth? Well, the HC took the position of trying, first of all, to map the directive, that is to consider provision by provision of the directive against the national laws of the member states, and understand which provisions need to be implemented from scrap, which only need to be amended because they are there but they're not perfectly complying, and which are in place. And the committee then focused on 7 areas of interest, which are those that you read on the screen, and today we will discuss the new trademark definition again, so very quickly. guarantee or certification marks and collective marks, and the administrative procedures for declaration of invalidity or revocation. So the new trademark definition, which, well, we saw a number of times today, is a key, actually, change because it affects all the countries. So this is new for everyone. And as we know, it opens not only to new kind of signs, but to filing the trademarks in new formats. So I will only, since we already heard earlier from Andras and earlier this morning from Dimitris Bortis about the common communication, I will only focus on what is likely to remain not harmonized, which are the searching capabilities of the offices, because of course that largely depends on the IT of the system of the single member states. So on the short run, we will possibly have a situation in which all the offices actually agree, for example, on what a multimedia mark is, but we will only be able to search these kind of marks in some offices, which is, by the way, the present situation, for example, for sound marks, which exist in all the member states, but can only be searched in roughly, let's say, half or more than half our member states. This is again, excuse me. Okay, this is again something that that we saw already, so I don't need to comment this. This also is our numbers that Boris gave us this morning, Dimitris gave us this morning. They are not exactly the same. Probably the date in which the search was made is not exactly the same. I only add that position, pattern, motion, and multimedia marks are not specifically recognized in the current legislation of the UK, so they all fall under the other category. Now, excuse me. So this is a second area of interest of the committee. So collective marks, as you know, are mandatory, whereas guarantee or certification marks are only optional for the member states. Collective marks are, in fact, defined and regulated in a substantially identical manner as in the EU TMR. There are reasons, however, why we should probably encourage the adoption of guarantee and certification marks in all the member states, even though it is only optional. I have some problems with this. Okay, so this is the definition of the collective mark under the directive. Although collective marks in fact exist in virtually all the member states, they are defined differently, so we will still need alignment and revision of the national trademark laws in order to comply with this new, let's say, definition. For example, this is a matter of example, Benelux, this is the current definition of collective marks, and you will see that it is rather broad and it actually encompasses what we would understand more as a certification of, or guarantee mark. And this is probably at the basis of the choice that Benelux made or will make if the draft is approved to introduce not only collective marks that would be introduced just mirroring completely the definition of the directive, but also introducing simultaneously collective and certification marks, and in addition providing a transitional period during which the owners of the old collective marks may decide, provided of course that their marks complies with one provision or the other, under which regime their trademark should go in the future. This is a situation which is similar to Italy. You can read that the present definition of a collective mark in Italy is in fact much closer to the one of certification or of a certification mark. And although the draft bill in Italy is not publicly available, We have been informed that, in fact, the plan is to introduce certification or guarantee marks also, as well as the collective marks. So, a guarantee or certification mark under the directive is, again, mirroring as a definition the one corresponding to the EUTMR. But there is a lot of room for member states because there are many optional provisions. I mean, it's not only the adoption of the marks as such is optional, but also the provisions that apply to them. So these are a couple, and since we have some time constraint, I will just go to the following slide. These are other optional provisions. And this also we heard, this difference between the EUTMR that does not allow for certification of geographical origin of the goods, whereas in the Trademark Directive this is an optional provision, and some countries, for example Spain and Italy, have in fact already signaled that they wish to implement this provision and allow for trademarks that certify the geographical origin of the goods. Then it comes to regulations that apply to these marks, and here, of course, we have again the liberty of the member states. We heard this morning that the EU IPO is working on templates, on models. So it may be expected that those will serve as a benchmark and that we will have another level of harmonization, let's say unofficial harmonization, even though it is not mandatory. And then finally, again, looking at the European trademark as a system where the EUTMR somehow interacts with the directive, this is a further incentive for the member states to introduce certification or guarantee trademarks, since conversion is expressly only allowed according to Article 93 of the EUTMR, only if certification or guarantee trademarks exist in the countries where conversion should take place. This is the last area of interest, well, the last area that we are discussing today of interest for the Harmonization Committee. So our trademarks battles of the future, which are the arms that we are going to use for our battles. They won't be swords, unlike the ancient Greeks. They will be, for sure, thanks to Article 45, more accessible arms. So I think that accessibility is the focus of this article. As we have heard already, the implementation deadline is only in 2023, but we have only also heard that a number of countries have decided or wish to implement the directive completely by 2019, including Article 45. This new provision, of course, aims to strengthen the rights of the holders, to bring simplicity, to reduce costs. So it is interesting for a number of reasons, but from the specific point of view of harmonization, the interest lies in the fact that it addresses an area where there's a very low, actually, level of harmonization and a great number of differing practices between one office and the other. So here are some examples. We have countries in the upper left corner where administrative procedures for revocation and declaration of invalidity are already there, and they are the only venue. Administrative is the only route for standalone actions. And we have, on the other hand, countries where there exists only a judicial route, and then we have a number of differing practices in countries where both the judicial and the administrative proceedings are available, either regardless of the grounds or depending on the grounds. So really the present level of harmonization is very, very low. The directive makes mandatory the administrative procedure for revocation for all the grounds of revocation and for only those grounds of invalidity that are mandatory according to the directive. So this means that there may be the case where some additional grounds for invalidity may, for example, only exist as at a judicial level, before the courts, and this seems to be, for example, the case of Italy. So, to what extent has a substantive law been harmonized? So, for example, the directive does not provide for legal interest. So here there might be a change in the countries where now a legal interest to act is required. The important, I think the most important thing is that somehow the implementation, the transposition of Article 45 should be managed with great care, especially when it comes to positioning the administrative procedure vis-à-vis the judicial ones. And, well, this is possibly one of the reasons why the term was extended, because it's a delicate matter. But the directive does not in any way impose that the IPO or whatever body that is competent for administrative proceedings is the exclusive venue. So there is ample space to maintain the competence of the IP courts where it already exists, and leave a choice to the active party to decide which venue in a specific case will be well, the more convenient or the more appropriate for the case. And well, one important argument in support of this choice of keeping the twofold system is that some offices, those where administrative proceedings do not exist yet, may really not have sufficient even skill, sufficient financial organization and resources and organization to treat these matters properly. Of course, eventually, once the directive is transposed, they will need to treat these cases, but they might have difficulties in treating them in an efficient and expeditious manner, which is required by the directive. Well, despite these recommendations that are not my own, but have come from many distinguished observers, there are some countries that in their proposed implementation scheme have shifted from the judicial route to the administrative route completely. This one of the countries is Spain, as you see, in validity based both on absolute and on relative grounds. According to the draft bill that we could access, would move and completely and only be discussed in front of the office. And on the other, completely opposite end, we have Benelux, where two different chapters were introduced in the draft law. So one is for the proceedings before the courts, and the other one is for proceedings before the office. So, summarizing, of course, the new directive seeks to reduce divergence and within the trademark system. And again, as I said at the beginning, we have never been so close to the shores, so close to reducing divergences. There still will remain some areas of non-harmonized substantive and procedural law, which at the end of the day is okay, provided that, of course, we are aware of all the differences and we are able to advise properly. As a harmonization committee, we will continue to implement this process, and so I take the occasion to thank all the members of the committee for their continuous effort and their dedication to this.
Thank you very much, Mara. Sorry. I'm sure the committee will closely follow all further developments and will also be there as soon as the trademark directive has been implemented, in order to see whether there might be some more need to come to common approaches. We will now come to the third part of our session, which is about the practitioner's view, because in the end it will be the people who have to live with the outcome of the implementation of the trademark directive. And so far we have heard from the offices, we have heard from our harmonization committee how everything will be implemented. But let's see how that will all work in the future and what kind of effects it will have on also our daily practice. And our next heroine, as I might refer to her, is Andrea Marx. Andrea is a German lawyer working for the firm Harms and Utischer, and apart from that, she is also the secretary of the ACTA Law Committee. And Andrea, please, you have the floor.
Thank you, Carolyn, for this kind introduction. I think thanks to Mara and Andras, we now know a little bit more about what ZEUS and the 28 gods of the member states are thinking and doing and planning to do with regard to the implementation of the Trademark Directive into national law. But what about us, the ordinary people, the practitioners that have to deal with the new rulings in the daily work? What will be the benefits for us? I do not want to bore you with running through each amendment that will come up with the new amendments in national law. I want to focus on two main amendments that are, from my opinion, of great importance for practitioners. So, I think two key changes will be the implementation of revocation and invalidity proceedings before the national offices and the extension of right holders' rights in custom-related situations. So let's start with the implementation of administrative proceedings in front of the offices. What is the frame that is given to the member states by the use from Brussels? According to Article 45 of the Trademark Directive, member states shall provide for an efficient and expeditious administrative procedure before the offices for the revocation or declaration of invalidity of a trademark. In the first step, we may recall how the current situation before the implementation of the Trademark Directive is. As we do not have the time to go through all 28 member states, I beg your pardon that I focus mainly on the situation in Germany in this regard. So how is the current situation? We have opposition proceedings based on relative grounds in front of the Patent and Trademark Office. And we have invalidity proceedings based on absolute grounds. But in Germany, we also have limited revocation proceedings based on grounds of non-use, trademark having become generic or misleading indication, or loss of trademark proprietability. So what do I mean when I say limited revocation proceedings? Until now, we only have a formal procedure, which means that the applicant can file a request for cancellation of a trademark because of non-use with the office. The office will then deliver this request to the trademark owner, and the trademark owner can object this request, and if he objects the request, then the proceeding in front of the Patent and Trademark Office is finished, and it is up to the applicant to proceed with a lawsuit in front of the courts. If the trademark owner does not object to the request for cancellation of his or her trademark, then the trademark will be cancelled by the office. So, until now, there are no invalidity proceedings based on relative grounds in front of the German Patent and Trademark Office, and no revocation proceedings with full competence of the office for examination and decision-making. In addition to the invalidity and revocation proceedings I mentioned before in front of the office, it is possible to go to the courts for a trademark having been declared invalid because of relative grounds, or for a trademark being revoked because of non-use, or trademark having become generic or misleading indication, etc. So this is the situation as it is for us as practitioners. It seems that the legislative authorities in Germany do not find this situation satisfying, but see the need for amendments to comply with the demands of the Trademark Directive. So what changes will come up? According to the final draft that is in the legislation process now, it is planned to extend the revocation proceedings on grounds of non-use, etc., to proceedings with full examination by and full competence of the office for decision-making. Furthermore, it is also planned to introduce invalidity proceedings on relative grounds in front of the PTMO. Court proceedings shall remain as an alternative. To avoid that it will come up to different decisions, there is a ruling in the draft where it is planned that if somebody filed, for example, a request for cancellation in front of the office, a lawsuit on the same matter and subject will be inadmissible, and vice versa. And it's also the same with uncontestable decisions made by the office or by the court, so also vice versa. So, what will be the benefits for us, for the practitioners, from the new situation? Of course, this can only be expectations because the new rulings are not in force yet. Okay. One issue that is always of interest for parties being involved in legal proceedings are costs. So, I think Mara mentioned it before, with the implementation of the full range of invalidity and revocation proceedings in front of the office, conducting such proceedings will become less expensive for the parties. One aspect is that the fees of the PTMO are much lower than the court fees. And another aspect is, and the lawyers in this room may not like to hear this, that you do not need to hire a lawyer if you want to file a cancellation request in front of the PTMO. But if you want to have a good outcome, or if you need to blame somebody for a bad outcome, maybe it will then be worth to hire a lawyer also. But the cost matter is not the only issue. Another benefit is that it will save time to go for a revocation proceeding because of non-use to the office, when the office will have the full competence of examining the matter and making a decision. And another very important aspect, I think, is that the new system allows the parties claiming an invalidity or ground for revocation of a trademark to choose whether it wants to file a lawsuit in front of the court or start an administrative proceeding. For example, if being the defendant in an infringement proceeding, it may be worth to think about filing a non-use cancellation request against the attacking trademark with the office, instead of filing a counterclaim in the infringement proceeding, as this will give you the opportunity that another authority will make a decision on this issue than on the infringement issue. Another aspect can, of course, be the delay that you may have or may be able to produce when you are filing a request for non-use in front of the PTMO. In most of the cases, I think the courts will suspend the infringement proceedings then. So finally, there are several benefits that will come up with the implementation of administrative proceedings in front of the offices. The other change I want to talk about, and that is of high relevance for practitioners, I think, is the extension of proprietors' rights in customer-related situations. According to the synthesis report on IP right infringement 2018, recently published by the EU IPO, the total contribution of IP right-intensive industries to the EU economy is approximately 42% of GDP, which means 5.7 trillion euro and 28% of employment. Compared to this, the direct economic costs to legitimate industries in the EU arising from the presence of counterfeits in the EU marketplace are almost 59 billion euro direct lost sales and almost 435 lost jobs per year. I think this clearly shows the relevance of any change an extension of proprietors' right may have. So what is in this case the frame set out by the EU? According to Article 10, Section 4 of the Trademark Directive, the proprietor of the registered trademark shall also be entitled to prevent all third parties from bringing goods in the course of trade into the member states where the trademark is registered without being released for free circulation there, where such goods, including the packaging thereof, come from third countries and bear without authorization a trademark which is identical with the trademark registered in respect of such goods, or which cannot be distinguished in its essential aspects from the trademark. This entitlement of the trademark owner, of the trademark proprietor, pursuant to the first paragraph, shall lapse if during the proceedings to determine whether the registered trademark has been infringed, evidence is provided by the declarant or the holder of the goods that the proprietor of the registered trademark is not entitled to prohibit the placing of the goods on the market in the country of the final destination. So let us have a look how the current situation before the implementation of the Trademark Directive is. Until now, the proprietor usually, I say only, has the right to prohibit the import or export of trademark infringing goods. As for the custom proceedings, the ECJ made clear that no suspension of release or detention of goods in transit is justified without any indications at least giving rise to the suspicion that the goods are intended to be subject of a commercial act directed to the consumers of a member state. This can be indications on sale of the goods in the member state or offerings for sale or advertising. Which means that if there are no such indications, counterfeits will pass the transit country and proceed to their final destination where they will be put on the market. And of course, this situation is very difficult for custom authorities as they have to decide very quickly if there are such indications or not. As for the court proceedings, infringement is only given if the proprietor proves that the goods are intended to be put on sale in the European Union. At this stage of the proceedings, a suspicion is not sufficient, but evidence of the proprietor is needed. So this can turn out to be a very heavy burden for the trademark proprietor. With the implementation of the Trademark Directive, things will change, and the proprietor's rights will be extended and enable the proprietor to prohibit not only import and export of goods, but any bringing of goods in the course of trade into the member states where an obvious infringement is given. As we read before in Article 10, an obvious infringement is given if the trademarks and goods are identical, or if the infringing sign takes over the main characteristics. As for the custom proceedings, custom authorities can suspend the release or detain goods from third countries that are obviously infringing a trademark, irrespective if there's any indication giving at least rise to the suspicion that goods are intended to be put on sale in the European Union. I think this will make custom proceedings much easier because, as I mentioned before, for custom officers it is very hard to find out if there are any indications that goods will be put into the market in transit country. So things will become much clearer for them. With regard to the court proceedings, the declarant or holder of goods must provide evidence that the proprietor of the trademark is not entitled to prohibit the placing of the goods on the market in the country of final destination. So this means that the burden of proof for infringement will be reversed in favor of the proprietor. I think it is more or less clear that these changes will have significant benefits for proprietors. As I said a few minutes before, custom proceedings will become much easier and much more effective. Trademark proprietors will be able to stop trademark or other right infringing goods at an earlier stage, and this will help them to enforce their rights. Furthermore, also the reversal of the burden of proof for infringement will facilitate court proceedings, and it will then be up to the declarant or holder of the goods to prove that the proprietor is not entitled to prohibit the placing of the goods in the market or final destination. So, all in all, the implementation of the Trademark Directive will give the proprietors better tools to act against counterfeits at an earlier stage. I think the implementation of the Trademark Directive will thus bring practitioners several substantial benefits. I highlighted here two main changes that will be of high relevance for us as practitioners. And I think we will see where we will stand in 1 year when some of or all of the member states will have introduced the new law and the new rulings, and we will then see how it will work in practice. Thank you very much.
Many thanks, Andrea, and great thanks to all our three speakers for their great presentations and for being quick, because I now realize that we still have some time for questions. Nearly 10 or 15 minutes for questions, which is great. So, if there is something you would like to know about the status of the implementation, this is now your chance. Be it regarding the practices of the national offices or regarding the view of a practitioner. Are there any questions? Please, Chris. Do you have a microphone?
I really have I have three comments or questions. The first is a most general one. And this arose in a British case referred to the Court of Justice when Sir Robin Jacob had something to say about it. In 1994, when we passed our Trademarks Act, in a few instances we did not use the actual language of the directive. And that actually causes problems for advisors. It's much better that you know that you've got the words of the directive and that is what will be interpreted. Otherwise, the Court of Justice may have a difficult job in interpreting what the legislation actually said, because it was different from the directive. The second matter, which I think is really for Andrea, is the procedural requirements. One thing I think is not mentioned in the the directive is a situation where there is already a pending case in the court for affecting the trademark, probably for infringement. And under the British procedure, you cannot then take a separate proceeding in the office. I think there's a lot to be said for keeping that in the courts. Otherwise, it causes problems. The case in the office may have to be appealed to the court. Lawyers will do very well, but that's not really the purpose of the system. And finally, this is for Andras. I hope I misunderstood him, but I thought he said that a trademark registered before the directive is implemented could later on be declared invalid because of a change in the law. Now, then the questions of rights of property in the trademark arise, and I don't think it's required. I've just looked at the draft of the UK regulation, which hopefully will be introduced quite soon, where it provides specifically that the commencement date is the 14th of January 1919. I think it's very undesirable that any validly registered trademark before the date of implementation of the directive could then later be declared invalid on new grounds.
Andrea and Andras, are the questions clear? Okay. Could you maybe, I don't know, Andrea, maybe you want to start?
Yes, thank you, Christopher, for your question. I understood that you asked how the new law will deal with pending cases. I think, of course, it depends on the rulings that will be made in the different draft acts. But I can imagine that if you have a pending infringement case and then the new administrative proceedings will be introduced during the time in front of the office, that it will be possible to go to the office and to file a request for cancellation of the attacking trademark there, for example. I do not see a reason why it should not be possible, because it is then a different proceeding. I do not think that it will interfere the rights of the parties in a way.
Andras, would you like to respond to the
Yes.
second question?
Yes, of course. Yeah, and also one remark regarding the implementation with different wording from the directive. Yeah, I mean, the default position is to implement it as it is in the directive, or at least as it is in the translation of the directive to the national language, which might already have certain flaws. But we also have to be very careful when we are doing that, because the transposition exercise is not something that you can do mechanically. You have to find the right terms in your national law. And if you are just using the directive's language, that might cause some confusion in national law, because the directive is drafted in a way to be general enough to cover different legal systems. And when you transpose it, that means that you are translating the provisions of that directive into national law, and that might require certain alterations, which doesn't mean that you alter the content of the provision, obviously. It only means that you cannot just take a word-by-word translation and put it in your national law, because that will possibly raise a lot of interpretation issues as well for the national judge. So I'm in agreement with you, so I'm not really disputing anything that you just said. I'm just saying that a literal translation might not work in all the cases. Now, regarding the transitional measure, regarding invalidation of previously registered marks, just a couple of points to raise here. First of all, this is not decided yet. This is in a draft. It can be contested in the consultation phase. It can be contested by the other actors of the ministries, Ministry of Justice. They should safeguard these constitutional issues. But this is not to admit that it would be somewhat unconstitutional to deprive holders of their property. This is a model that has been applied upon EU accession of the country, and it has never been contested. There also were changes in the grounds for refusal, and this kind of middle ground was acceptable by all the interested parties. Now, what are we talking about here? You did not misunderstand me, but we have to bear some very significant safeguards in mind. So we are not talking about taking away previous rights retrospectively. So what we are talking about is avoiding that something that is not compliant with trademark law anymore can stay there forever and ever and ever. Otherwise, I mean, we could count with a surge of applications which still want to be there before the transposition of that directive, because they know that under the new rules they wouldn't be eligible, which is probably not desirable. And it's also not desirable to have new rules, to clarify rules, and then have non-compliant marks there forever. Now, this only concerns a very small percentage of cases, but the principle is principle, so it's equally important. So to have this very delicate balance and say, yeah, legal certainty is there, you cannot be deprived of your property, but let's not have non-compliant trademarks in the system forever. There is this method, legislatively, to say that, okay, you are safe until the first renewal date after the entry into force of the new rules. You are safe. Nobody can touch your mark until then. Afterwards, new grounds may be invoked against it. And even if those proceedings are successful, your protection will only cease to exist from the first renewal date after the entry into force. So those proprietors of marks who think that they would fall under a new ground for refusal after the entry into force of the new rules have time to alter their mark or have a new registration until that time and prepare for the consequences of this. It is debatable, but one might feel that this is a fair balance between the conflicting interests at stake. Thank you.
Thank you very much, Andrea and Andras, for your explanations. We have time for another question. Yes, maybe you can briefly state your name and the country where you come from. Thank you.
I'm Ewa Skrzydło-Tyfelska. I'm coming from Warsaw, from the SKS Law Advisors. And I have a question for Andrea regarding the goods in transit and the potential defense of the importer that at the place of destination, the owner of the trademark will not be able to stop him from selling. And what is of interest for me is the evidence that should be produced, because it is not an easy question of just having or not having a registration, because there might be other rights interplay, like unfair competition, priority of use, well-known trademarks, and this evidence will be evaluated by different courts than the courts that would be evaluating in the place where the goods are to be placed in the end. So what would be your suggestions how to resolve this problem?
So if I understand your question correctly, up to the new rulings, the declarant or holder of goods must provide evidence that the proprietor is not entitled to prohibit the placing of the goods and market in the of a final destination. But I think, do you want to say something?
I agree.
Okay. So I think you are absolutely right. It will be up to the courts to decide what will be accepted as evidence. For the moment, to be honest, I do not know what will be accepted. Maybe today there is a further session on counterfeiting, and maybe we will get there a little bit more ideas about what evidence in this regard can be.
Thank you, Andrea. One more question could be answered. I don't see anything. But our speakers, I think, have been... Oh, yes, there is one.
Jarosław Kulikowski from Poland. I have a simple question to Andrea. Sorry for this, but you mentioned that cancellation proceedings before the PTMO will be cheaper than before the courts, assuming that the quality of proofs and the quality of argumentation stay the same. So why is that?
The proceedings, cancellation proceedings in front of the PDMO, I think, will be less expensive because the fees of the PDMO are much lower than the court fees. I can say this definitely for Germany, but I think this is also the case in many other countries. For example, in Germany, I think it is in the draft that the fees for a revocation proceeding can in the end sum up only the pure official fees to 400 euro. So I do not think that you will be able to have a court proceeding on this issue with for 400 euro court fees. And in addition to this, it is, for example, in the grounds of the German Draft Act, that another aspect that will lower the costs is that you do not have to hire a lawyer to file a cancellation request for non-use, for example, in front of the office. And in Germany, you have to hire a lawyer to file a lawsuit and go through a court proceeding.
Mara, you add
No,
something.
and if I may add something, many countries are likely to adopt a EU IPO model where, for example, revocation on non-use grounds will be a matter of filing a form, whereas before the courts in many countries you need to file a full statement of grounds. So this possibly makes a big difference when it comes to costs, apart from the official fees.
Thanks for these questions, answers, and the discussion. I'm very happy we were able to have a little bit of exchange of views. I would like to thank our speakers for their wonderful presentations. And the outcome seems to be that all these gods will fulfill their duties in time, so that hopefully the new trademark temples will gleam in new splendor soon, and that there will be no need for Zeus to throw another lightning bolt and have some member state infringement proceedings or something like that. Nevertheless, we do live in challenging times. You all know that one of these goddesses would like to leave the Olymp. We will touch upon that later today. To discuss more Brexit-related issues, because it's very interesting. You know, even if the UK now implements the new trademark directive, what will happen afterwards? Will they still keep on some of these new rules, or will they develop something completely else? It remains extremely interesting. And what do we learn from, you know, drawing conclusions and comparing our IP world with this ancient Greek civilization? We also have it standing there, crossroads of IP civilizations. I think we have to consider that these gods in the end always remembered their responsibility towards their people, They always remembered that they were one powerful union, one powerful family. And maybe this helps us in the future to also be aware of our own responsibilities and to find ways to agree on common solutions, because this is, I personally think, the only way we can deal with this in this challenging time. So, be it in the inner circle of the Olymp or outside. Thank you for your kind attention, and now it's time, if we stay in the picture of the gods, for nectar and ambrosia. So enjoy a divine meal. Lunch is served, and we hope to see you soon again to discuss more of these questions. Thank you.